If you need to open a California probate in order to administer an estate, you may want to know how long the whole process will take. Hi, I'm Paul Groh, Director of the Estate Administration Department at the Law Offices of Daniel A. Hunt. The probate process in California is driven by a series of tasks and events that must be completed per the probate code. The completion of the tasks will drive the length of time that it will take to probate an estate. So what is the timeline for a typical California probate? Here's an outline of the most common steps in a probate. First, you'll meet with a probate attorney to discuss your case. We created a tutorial on how to prepare for your initial consultation with a probate lawyer. There is a link to it in the description for this video. Second, file your probate petition. About 2 to 3 weeks after you've hired a probate attorney, they will draft and file the appropriate probate petition and supporting documents at the probate court in the county where the decedent was a resident. Third, publish and mail notices. After filing your petition, your probate attorney will need to publish a notice of the court hearing date requesting that the estate administration be opened with the court. This notice will appear in a newspaper of general circulation in the city where the decedent lived. They will also mail a notice to all heirs and any beneficiaries named in their will, if they created one. The purpose of these notices is to place heirs and creditors on notice of the proceedings, in order to begin statutory periods for interested parties to bring their claims against the estate before the court. Fourth, initial court hearing. Your probate attorney will attend the initial court hearing at the courthouse where the petition was filed. At the hearing, the judge will sign an order for probate, appointing the personal representative of the estate. When will the hearing take place? The time frame depends on the county. For example, at the time of recording this video, a hearing in Sacramento County will take about 16 weeks after filing the probate petition. Fifth, bond issued. If the judge orders you to obtain a bond, you'll need to secure one. This is basically an insurance policy to protect the estate against the risks of mismanagement by the personal representative administering the estate. Sixth, court issues letters. This document shows that the personal representative is authorized to act on behalf of the estate. If your bond was in place at the hearing, or no bond was required, you should receive these at the initial hearing. Once you receive letters, you will be able to show them to any financial institutions in order to begin the work of the estate administration. 7. Collect and inventory assets. After taking an inventory of all estate assets, the personal representative may begin to liquidate personal property, including treasury bonds or investment accounts, to convert them into cash that can later be distributed upon a court order to the heirs or beneficiaries, unless there is a will that directs to distribute the assets in kind. 8. Send notice to creditors to any known creditors. Creditors have 4 months to file any claims with the court. Your probate attorney can help you respond to any existing creditor claims. This can get tricky, as not all claims have the same priority under the probate code. You'll want an experienced probate attorney to help you handle creditors. 9th, sell real property. The personal representative may sell real property assets if necessary, as long as full authority has been granted by the court. If the court only granted you limited authority, then the court must confirm any sale of real estate. 10th, file an inventory and appraisal with the court. A probate referee will complete an appraisal of the estate within 90 days of receiving your letters. 11. If the decedent owned real property, must file a change in ownership statement, death of real property owner, with the county assessor. This form lets the county know that the owner of the real estate has died and informs them of the identity of the personal representative of the estate. This typically happens 4 to 6 months after filing the initial petition. 12th, pay final income taxes. This should be completed before filing a petition to distribute the estate. Your CPA can help you file a short year income tax return if appropriate, so you do not have to wait out the year in order to close the estate. 13th, file a petition for final distribution with the court. This indicates that all debts have been handled, all required steps have been taken, and you are ready to close the estate and distribute the assets. This happens 8 to 16 months after filing the initial petition to open the probate. Finally, a final court hearing. You and your probate attorney will appear in court. If all goes well, the judge will give you a signed order allowing you to distribute the assets to the heirs. The length will vary based on many variables, including how backlogged the court system is in that particular county at the time. Overall, you can expect to spend at least 10 to 18 months in the probate process, from filing the original petition to distributing estate assets. As you can see, California probates are complex, and you'll want an experienced probate attorney coaching you through the process. If you have any questions regarding California probate process, please contact our office. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.